All right. Good, Lilia?
Yep,
Okay.
recording is on.
Great, awesome. So we'll get started. As I said, I'm Julia O'Leary. I'm our General Counsel here at Mass Office on Disability, and you are here for today's Level Up to Equality seminar for Municipal ADA Coordinators. So we'll start with an overview of what MOD does. Mass Office on Disability. We are a statewide agency that works to ensure that people with disabilities can equally participate in all aspects of life in Massachusetts. So that's a really broad mandate. And most of what we do is provide information, guidance, and training on disability-related civil rights and other access issues, including issues related to architectural and programmatic accessibility. And that sort of translates into a bunch of different duties. Mass Office on Disability is the ADA coordinator for the executive branch of state government. We also sit on the Massachusetts Architectural Access Board. We administer a grant program, the Municipal ADA Improvement Grant Program, which we'll talk about a little bit later in this seminar. We serve as a technical advisor to local commissions on disability. So if you are part of your municipality's Commission on Disability and you have questions, feel free to give us a call. We're also the designated client assistance program for the state of Massachusetts. And the Client Assistance Program is a federally funded program that provides assistance to people who are navigating the independent living or vocational rehabilitation services. We also offer a personal emergency preparedness program. So if you're interested in setting one of those up for your community, please reach out to us. And we are the state affiliate to the New England ADA Center here. So today we're going to kind of do a ADA Coordinator 101 for municipalities training. So we're going to start by going over disability laws, both at the federal and the state level. And then we're going to really focus on the Americans with Disabilities Act for the rest of the training today. And we're going to focus specifically on Titles I, which is employment, because municipalities are pretty big employers. And we're also going to focus on Title II, which are the requirements specifically for state and local government services under the Americans with Disabilities Act. And we're going to end, if we have time, with a couple interactive scenarios, which I think are kind of fun to practice what you learned today. And then the last page of the slide deck, and why I think it's so important that everybody has a copy of the slide deck, we have links to different resources that can be really helpful in your role as a municipal ADA coordinator, person in the municipality who is responsible for compliance with the ADA. So if you don't have a copy of the slide deck, please reach out after this presentation and we will make sure that you get a copy so you can have access to those great resource links at the end. So we're going to start with an overview of disability laws that are relevant to you and your role as municipal ADA coordinator. At the federal level, I like to start with the Rehabilitation Act of 1973 because it's really what started everything. Section 504 of the Rehabilitation Act required that federally funded programs, so all federal programs, any programs receiving federal dollars, must be accessible to people with disabilities, and introduce this concept of providing reasonable modifications to services or facilities in order to allow that access. In 1990, Congress decided, these civil rights need to apply not just in the scope of federal programs. We want to make that apply more widely. And they passed the Americans with Disabilities Act, which applies to employers, Title I, state and local governments, Title II, places of public accommodation. In Title III, in places of public accommodation are any place that holds itself open to the public. It also applies to telecommunications and transit. So that is a really broad and sweeping legislation, requires access for people with disabilities, and requires entities to provide modifications in order to make them accessible. In 2008, Congress amended the ADA to make clear that the ADA is intended to be applied broadly. So it broadened the definition of disability, and it broadened it clarified the intent of the statute is to be applied broadly to provide the maximum protections to people with disabilities. Then on the state side, we have the Massachusetts Constitution, Article 114, which provides for civil rights for people with disabilities baked into our Constitution, which is, I think, really cool and makes Massachusetts really stand out in the disability rights field nationally. Those protections are sort of operationalized, enforced through the Massachusetts Equal Rights Law, Chapter 93, Section 103. And then with respect to housing and employment, we have Massachusetts Chapter 151B, which prohibits discrimination against people with disabilities in housing and employment. The employment provisions are pretty close to what's in the Americans with Disabilities Act. The housing provisions are pretty close to what's in the Fair Housing Act, but then at the state level and enforced through state administrative agencies, namely the Massachusetts Commission Against Discrimination. We also have a public accommodation statute, and I threw the service animal statute in there too. It's a little broader than what you see at the federal level, requiring that service animals be allowed in places of public accommodation. So we're going to sort of focus today really on the Americans with Disabilities Act, and that's the lens through which we're going to be approaching the concept of access, and specifically we're going to focus on Titles 1 and 2, which are the two titles that I think are most relevant to you folks in your role as Municipal ADA Coordinator. Title 1 is about employment, and Title 2 is about state and local government services. And as we start, I think it's really helpful to keep in mind how disability is defined under the ADA, so that it's really clear, who are we talking about? Who is protected by these statutes? And so under the Americans with Disabilities Act, and this is the definition is very similar under state law, disability is a physical or mental impairment that substantially limits one or more major life activities. And so what I think it's important to keep in mind that this is a really broad definition. You can't sort of look up a list of impairments somewhere and have it be definitive. It's really going to be evaluated on a case-by-case basis, and it's intended to be broad, right? Especially clarified by the ADA Amendments Act of 2008. This is a broad definition, but it's not, sort of so broad that it's meaningless. There's sort of questions that you have to consider when you're thinking, is this a person with a disability who is sort of before me asking for something? And the three questions I have people sort of think about are, Is there a physical or mental impairment? Does that impairment exist? If it does exist, is that impairment substantially limiting? And when courts think about whether an impairment is substantially limiting, they're looking at severity and duration. And I sort of, when I'm talking to people about this, I tell them to imagine an axis where you have, you know, on one axis you have severity, and the other axis you have duration. Sort of the more severe and the longer lasting an impairment is, the more likely it's going to be considered a disability. The less severe and the less long lasting, the less likely it's going to be considered a disability. And then of course, you know, we're human beings, so almost everything is in the middle. You have some things that are very severe but not long lasting, that might rise to the level of disability, or you might have something that's not very severe but is permanent. You know, the court is going to weigh that. And so there is a certain level of judgment call when you're deciding, is this someone with a disability? Is it not? What you're going to be thinking about is how, you know, how substantially limiting is this impairment that the person has in order to be covered under the ADA. And the last question is, does the impairment affect a major life activity? And a major life activity, again, really broad, any activity that's of central importance to daily life. So that can be something really obvious like walking, breathing, talking. It can be things that are less obvious, you know, immune function. It could be reproduction. So that's sort of how you're going to approach that initial question of, is this a person with a disability under the ADA? The ADA also protects people who do not actually have disabilities, so they don't meet that three-part definition, but they're either used to have a disability that no longer affects them, or they're perceived as having disability. Now, people who fall into these two categories are protected from discrimination under the ADA, but since they don't have an actual disability, they are not entitled to a reasonable accommodation. So sometimes I get questions about that. You know, and we'll talk more about reasonable accommodations as we continue. We're going to focus on employment first, because cities and towns are big employers. And as an ADA coordinator, you've got to think both from an employment perspective and from sort of a public services perspective. So we're going to start with employment. Under Title I, the ADA prohibits discrimination against qualified individuals on the basis of disability in regards to job applications, hiring, advancement, and pretty much all of the terms and conditions and privileges of employment. That's really broad, and it's not just sort of limited to discrimination in sort of the performance of job duties. It's all of the terms, conditions, and privileges of employment. So that is in benefits plans. It is in, you know, being able to access the, you know, the holiday office party. It's any sort of benefit that someone gets from being an employee in your municipality. And discrimination can sort of be a host of different things. It can be an adverse action. It can be excluding someone from the benefits of a job. And it can be failing to provide reasonable accommodations to otherwise qualified employees. We're going to talk about reasonable accommodations. And when we talk about reasonable accommodations in the employment context, it's going to be really similar to the reasonable accommodations or reasonable modifications, sometimes I'll call them, under Title II in the state and local services context. So keep this definition in mind as we go forward. A reasonable accommodation is any adjustment or alteration to the workplace or, you know, later to a service or facility that enables a person with a disability to apply for jobs, to perform the essential functions of the job, or to enjoy the benefits and privileges of employment. These can be really broad, which is sort of the theme of the day, really broad. These can be auxiliary aids or services. So it could be an ASL interpreter or CART services or live transcription services. Could be equipment such as a standing desk or a Braille keyboard. Could be removing barriers. So installing automatic door paddles for your office building, making sure that hallways are free from obstructions. And then the broadest one could include reasonable modifications to policies, practices, and procedures. So that might mean allowing someone to have a modified work schedule as long as they can get their work done during different hours. If they need to, attend early morning appointments or, their disability prevents them from sort of working a typical 9-to-5 schedule. It could mean allowing telework if appropriate. There's a lot that it could even be having sort of alternative procedures for evaluating performance. It can be you can be really creative there, and that's where you see a lot of opportunity for creativity in this process. An employer can deny a reasonable accommodation for 3 reasons. And this is going to come up again when we're talking about Title II. But you have 3 sort of grounds for denying a reasonable accommodation. You can deny it if it would create an undue financial burden. One thing to keep in mind about undue financial burden is that the court will look at the town's budget as a whole. They won't just look, say, at the Parks Department's budget. They'll look at the entire town budget for that fiscal year. So keep that in mind. And then undue administrative burden, which would mean that the requested accommodation would just create too much of a burden for the town to be able to fulfill. And then finally, fundamental alteration means that this accommodation would change the nature of either the task being performed or would fundamentally alter maybe physically the environment in a way that is not reasonable for the town to do. So when you have an employee who has requested a reasonable accommodation, that request can be made to anyone sort of above the employee in the hierarchy. So it could be made to a supervisor or manager, or it can be made to the ADA coordinator. The ADA coordinator needs to sort of know about these requests so that they can take them on and be responsible for coordinating the request. You want to have a set process in your municipality for handling employee requests as well as requests from members of the public. Keep in mind that folks do not need to self-identify as a person with a disability ahead of time before they can request a reasonable accommodation. That's considered a separate process. Okay. And then as you get these reasonable accommodation requests, your obligation is to engage in what we call the interactive process. And this is sort of the cornerstone of Title I of the ADA. Courts want to see that you have engaged in a meaningful dialogue with your employee about what they need and how their need relates to their functional limitation. Your goal is to find the best way to sort of meet the employee's need so that their functional limitation isn't a barrier to them fully participating in the workplace. So you're going to need to have that conversation with the employee to talk about their needs and their functional limitations. You're going to need to talk to the manager to figure out what would be reasonable here, what's doable. But you need to be really careful not to provide the manager with medical information that they don't need. So you can explain to the manager what the employee's functional limitations are. You shouldn't be talking about their medical information though. If the manager is sort of pushing back, says, we really can't implement this as requested, you should work with the manager to come up with alternatives. And that's a really important part of this interactive process. Try to problem solve. And we're always here as a resource if you need ideas or need help problem solving how to meet an employee's needs. And it's a good idea to establish a reasonable time frame for responding to these requests. I think it's really good to have a written policy that kind of outlines your process for intake and response to the reasonable accommodation requests you get from employees. As you're going through this process, as I said, your goal is to assess how a person's functional limitations interact with the essential functions of their job. It's not a one-size-fits-all analysis. And so, we really need to drill down with the employee's manager to understand what parts of this employee's job are essential. You are not required to waive essential job functions, but you may be required to waive non-essential job functions. So as you're doing that analysis, you're going to be thinking about, does the position exist to perform this function? What is the consequence of the employee not performing the function? Are there other employees available to perform the function? And what level of expertise or skill is required to perform the function? So one function that has come up a lot over the last 2 years is opening mail. A lot of people, a lot of managers are saying, oh, I need so-and-so to come into the office every day to open the mail. And so they can't telework. You get a lot of requests these days for working from home. And so as you're sort of working through, is being physically present in the office an essential function of the job? Do they really, is this opening the mail daily, is it an essential function of the job? You're going to ask, does the position exist to perform the function? Is this a mailroom person? What happens if the person doesn't perform the function? Is there someone else who's available to open the mail? What level of, is this like a high level, high skill function that we can't transition to someone else because it's a specialized function that we hired this person to be able to perform? You can also, as you're assessing these essential job functions, you can look at the original job posting. Courts love to do that. So, think about how you originally described the job when people were applying. That's going to guide you as to what was really considered essential. People really get caught up on medical documentation. You want to make sure that someone is actually a person with a disability, and that is, reasonable. But you need to be careful when you're requesting medical documentation, especially if the employee's disability is obvious. If the disability is obvious, you should not be requesting medical documentation at all. In fact, that saves you a lot of time and effort. So that's a good thing. If the person's disability is not obvious, you can request medical documentation to verify that a disability-based limitation exists and that the disability necessitates the reasonable accommodation requested. It can be really helpful to talk to an employee's physician about alternatives. If the specific accommodation that someone requested isn't feasible, it can sometimes be helpful to run alternatives by the physician to make sure that that will work with the person's functional limitation. But again, if the person's disability is obvious, or if their need for a particular accommodation is obvious, you should not request any medical documentation. And that can actually be considered discriminatory. Once you've sort of arrived at the end of your interactive process, you're going to need to make a decision about whether or not you're going to grant or deny that reasonable accommodation. And you should do that in writing. I tell people to write a letter to the employee that describes what the decision is. So if you're approving the request for reasonable accommodation, be really specific about what accommodation has been approved, provide a lot of detail, as much detail as you can. If equipment is being ordered, list what specifically the equipment is and when you're anticipating it will be delivered. If it's more of a programmatic scheduling change, maybe be really precise about the contours of that change. And sometimes it can be helpful to include a review date. We're gonna allow you to telework for the next 6 months, but after 6 months, we're going to need to review the situation further and make sure that things are still working out. I think that can be really helpful. If you're denying the reasonable accommodation, you should absolutely do that in writing, and you should list one of those 3 reasons or more than one, if more than one apply, of why you're denying it. And so you would either list that the request created an undue financial burden, an undue administrative burden, or constituted a fundamental alteration. You need to list one of those 3 if you're denying it. If you have approved it, you should only inform staff who need to know about the accommodation, and you should only give them as much information as they need in order for them to perform their duties. So if you need to have someone order a chair, you're going to need to tell them to order the chair, what the chair is, and probably who needs it and where it needs to be delivered, but you wouldn't give them any information beyond that. If you're denying a reasonable accommodation request, you don't really need to share that information with anyone because it's not relevant to them, because there's nothing for them to do. If you're denying a reasonable accommodation request, you should notify the employee that they can consult with an attorney or advocate, if they have a right to file a discrimination complaint at the MCAD or EEOC. It's also a really good idea, and I would encourage all municipalities to establish an internal appeal process that can cut down on your complaints to the MCAD or EEOC, and helps resolve things more quickly for employees and for management, because it can be a big time and energy commitment to have to go through the MCAD or the court process. And if you need sort of some ideas about how to write an appeal process, I'm happy to help you troubleshoot that. So that is our sort of introduction to Title I. And now we're going to dive into Title II. And I will take questions at the end. So if you have burning Title I questions, we will get to them. We're proceeding at a good clip, so I'm hopeful. Title II is the title within the ADA that applies to state and local government services. So that is sort of the municipality facing out into the world to its constituents. And the bottom line of Title II is that state and local government programs, buildings, and services must be made accessible to people with disabilities. And sometimes that's going to mean providing a reasonable accommodation upon request. So told you that phrase, reasonable accommodation, is going to sort of live with us throughout this training today. Members of the public can also request reasonable accommodations in order to access your government services. So what do you need to keep in mind under Title II? You cannot refuse participation based on disability. So you can't have entrance requirements or sort of conditions of participation for your local government services that discriminate against people with disabilities. You need to provide integrated settings to ensure equal opportunity. So you shouldn't have one set of services for people without disabilities and another set of services for people with disabilities. You need to eliminate eligibility standards or rules that deny equal opportunity to people with disabilities. You should enact grievance procedures to respond to Title II discrimination complaints. MOD has some templates for grievance procedures that we're happy to share if you want to reach out to us. And then finally, you need to make reasonable modifications to allow people with disabilities to access your services or your facilities. And what does that mean? That providing reasonable accommodations can mean a lot of different things in the municipal context. You may need to make sure that your website is accessible to people using screen readers, to people who maybe use keyboard only, to people who are colorblind. There are really good web accessibility standards by the Worldwide Web Accessibility Consortium. And we have some staff at MOD who kind of focus on web accessibility if you are looking into that for your town. It might also mean allowing service animals to accompany constituents to municipal facilities. It might mean providing American Sign Language interpreters during meetings or events, or providing reasonable modifications to municipal ordinances. If someone needs a, say, a special permit to build a ramp, we'll get to this later, you may need to think about that in your your permit approval process. So you might need to modify how you normally approve permits in order to make an accommodation for someone with a disability. As with the employment context, you do not need to provide reasonable accommodations that constitute undue financial or administrative burdens or would fundamentally alter the program, but you do need to engage in the interactive process, much like we talked about in the employment context. Now, municipalities also need to keep in mind physical accessibility of town facilities and buildings. Good guidelines for physical accessibility are the Massachusetts Architectural Access Board regulations and the 2010 ADA design standards. Generally, you would follow whichever would provide more access. We also at Mass Office on Disability have a municipal ADA improvement grant program that can help you pay for projects to improve accessibility at your municipal facilities. So that could be improvements to city or town halls, schools, libraries, sidewalks, parks, pretty much any town-owned facility or building. A little more on that. This grant program supports capital improvements aimed at improving programmatic access or removing barriers in municipal facilities. We have both planning grants. So planning grants allow you to create or update your town's self-evaluation or transition plan. And then project grants allow you to take action on those issues that you identified in your self-evaluation or transition plan, and take some action on removing architectural or communication barriers in municipal facilities. So some examples here, we've funded some projects to improve beach access by the town bought some beach access mats and boardwalks to allow people to access town beaches. We've had towns install assisted listening devices in town meeting rooms to improve communication access. And that's, become kind of a big one as we're moving into this age where more meetings have been held digitally. It can be helpful to have some access devices to help make those meetings more accessible to people with disabilities. And then we've had towns install accessible pedestrian crossings. We've had towns update their signage to make signs more clear and more accessible to people with disabilities. So those are some projects to keep in mind. We will be posting our grant applications for fiscal year 23 this coming August. So it's a good time to think about whether your municipality would benefit from some funds next fiscal year. So some tips on complying with Title II. It's a good idea to post a non-discrimination statement in all municipal facilities and on your website that includes contact information for your ADA coordinator, so that if a person who is interacting with the municipality somehow needs to request a reasonable accommodation, it's really clear how they would do that. It's really important to establish a procedure for responding to requests for reasonable modifications internally, so that you know that you have sort of checks that this work is actually getting done, and externally, so that people know what to expect when they're going to make a request. When you are holding meetings or events that are open to the public, make sure that the invitation and any notices include the ADA coordinator's contact information. You might recall that for this event, the invitation had a little blurb in it: contact Julia O'Leary, I'm our ADA coordinator, contact Julia O'Leary for reasonable accommodations. It's good to do that on, meeting notices when you're posting your notice for a public meeting. Really, really good idea to put in there your ADA coordinator's contact information, so that members of the public always know how they can request a reasonable accommodation to be able to fully participate. And it's really important to train municipal staff about how to keep facilities and services accessible. If you need ideas for that, please feel free to reach out to us. And finally, think about accessibility early and often. As you're making plans for any municipal project, think about how people with disabilities are going to be affected by that. So if you're planning a website redesign, think about how you're going to make sure that you have the opportunity to do accessibility testing before you go live. If you're building a new school, think about how people with disabilities are going to physically access that school, how they're going to access the environment during construction. When you're thinking of the new, summer camp for kids, how are you going to make sure that that summer camp services are accessible to people with disabilities? So we do have time for some scenarios. So this is the time to wake up and shake off. I like to open this up for folks to take a crack at. So if you want to try to answer this question, feel free to raise your hand and Lilia will call on someone. Here's our first scenario. Susan Miller recently purchased a home in the municipality. She uses a wheelchair, and she's requesting a zoning variance to allow her to build a ramp into her home that would extend 5 feet into the front setback. Her application doesn't meet any of the requirements for variances in the municipality's zoning ordinance. So how would the ZBA handle this request? Anyone want to take a crack?
Mark Dempsey's got his hand up.
I don't believe that Massachusetts would allow the ZBA not have to deal with that at all, because Massachusetts zoning allows that to be built right to the property line.
Well, this is a hypothetical question that Mark.
So, I work in the building department. I'm also going to be the ADA coordinator for Framingham.
Oh, good. Wow, that's great. But if it was, if you couldn't, let's just pretend we don't have that zoning law in Massachusetts. How would you sort of have the ZBA handle that request?
I basically say for accessibility, you would have, you have to allow the accommodation.
Yeah. I think you'd have to. That would be an example of a reasonable modification to the town ordinance for that person, for that person's disability. Very good. Thank you, Mark. So our next scenario is employment scenario. Mason is an administrative assistant for the select board. One of his primary job responsibilities is compiling meeting minutes and distributing them to the select board members for review 1 week before the next scheduled meeting. He's successfully performed this duty for about 4.5 years, but over the last 6 months, his performance has declined. The town manager gives him feedback that he's been missing deadlines and that the recent month's minutes have been inaccurate. During the meeting, Mason tells the town manager that he's experiencing anxiety and depression and asks if he can have additional time to prepare the minutes. How can the town manager respond? Do you have any takers for this one?
Feel free to put your comments in the chat as well, and I can read from there.
Anything, Lilia? Well, I can answer this. So this could be seen as a request for a reasonable accommodation, because he's asking for some kind of change based on anxiety and depression, which could be a disability. So the town manager should refer this over to the ADA coordinator. The ADA coordinator should then engage in the interactive process with Mason. First, should go through the process. Does Mason have a disability? Sort of get some more information about that anxiety and depression, because it's not obvious disability. You can ask for medical documentation. So once the ADA coordinator satisfies themselves that Mason is a person with a disability, he's going to go through the interactive process with Mason to see, what specifically is Mason asking for in order to accommodate his disability. And then he's going to have to talk to the town manager about whether those accommodations are reasonable, whether they would meet the needs of the select board, right? The select board needs to be able to review the meeting minutes in a timely fashion before the next meeting. So it might not be reasonable to provide additional time, but maybe there's other accommodations, some kind of speech to text tool that you could get from Mason to help him with note taking, to make sure that they're sort of accurate and compiled in a timely manner. And then,
so we do have some comments here, Julia. I think you addressed these, but somebody did ask if the condition is diagnosed by an MD or would need to be diagnosed by an MD.
Yeah, I think you could get an invisible disability. A psychiatric disability is usually considered an invisible disability. You can ask for medical documentation from the person's medical provider to verify the existence of the disability-based limitation and to verify that the accommodation is necessary to accommodate that limitation.
And then we have a comment from someone saying you would need to weigh the request against the rules that govern these meetings, and if you can accommodate, you should. If you deny the request, it has to include one or more of the 3 reasons to do so.
Yeah. And one other thing to just add is that I see a lot of times with employers, folks will come forward with a reasonable accommodation request in the context of a negative performance review. And I want to make clear that you can provide negative performance feedback and you can discipline employees who have disabilities. You can't discipline them because of their disability, but that disability doesn't become a force field against negative performance feedback. And one of our resources on the last page is a guide from the DOJ that goes into really nice detail on how to provide performance and behavioral feedback to employees with disabilities to make sure that they're still meeting the standards set by the employer.
We have one more question here. What's the role of human resources? The role of human resources versus the ADA coordinator in Title I accommodations request?
Good, really good question. So I think you're going to have to decide that for your particular town. I think it's really helpful to have there be a bit of separation between human resources and the ADA coordinator. The ADA coordinator's sole focus is on compliance with the ADA and local, state disability laws. And so it can be helpful to have a little bit of distance from human resources so that the effectuator and the decision maker are separate. But you are going to have communication between the ADA coordinator and human resources if somebody needs to have a scheduling change, if there's leave involved, if there's some kind of performance problem that needs to be addressed. So you'll need to have a connection. You're going to have an exchange of information, but you should kind of keep in mind that the ADA coordinator's role is to make sure that that you're following the Americans with Disabilities Act. And even sometimes, the ADA coordinator and an HR person will be the same person, but you're going to have to, keep those hats separate as best you can. I know oftentimes in state and local government, we wear a lot of hats. So if you need help navigating that on a case-by-case basis, I'm happy to chat about it offline. Let's go to our last scenario, and then we can open it up to questions because we've got about 10 minutes left. I want to make sure we get to questions. Norman is a newly appointed member of the Historical Commission, which meets monthly on the 2nd floor of Town Hall. Norman uses a wheelchair. Unfortunately, Town Hall's elevator has been broken for several years, and the 2nd floor is currently inaccessible to Norman. Are there some solutions you can think of that could make these meetings accessible to Norman? Anyone want to hop in?
Somebody says move the meeting.
Yeah, moving the meeting would definitely be an accommodation.
And Amanda's got her hand up.
Isn't it a violation of open meeting law to have a meeting that can't be accessed by the public fully? So
Yeah,
wouldn't they have to cancel those kind of meetings?
You would have to move the meeting. Yes. You would want to move the meeting. I also put this in here because you might want to think about repairing that elevator, and you might want to apply for an ADA municipal improvement grant in order to make that Fix the Elevator.
Nice plug. Yeah, we've got Fix the Elevator, Go Online.
All really good ideas. All right, so I'm going to show you our resource page. These are all really good links to resources that I use all the time when people come to me with ADA questions. We've got a link on here to our Municipal ADA Improvement Grant Program. We've got a link to the MCDHH, the Mass Commission on the Deaf and Hard of Hearing's interpreter and cart referral service, if you need a quick and easy link to that. So if you need a copy of the deck, please let us know and we'll make sure you get this. And then, please reach out to us if you need assistance, if you have a specific question. We're happy to talk you through them here at Mass Office on Disability. And let's open it up for questions, Lilia, because we've got a little bit of time left.
Great. Yep, we've got a couple questions. So I'll jump right into it. Our first question is, if a reasonable accommodation was granted to an employee by an ADA coordinator who no longer works there, does that accommodation still stand after that ADA coordinator leaves? And would the new ADA coordinator need to review that?
Yes. So in short, yeah, probably it would still be in effect. You should find that accommodation approval if you can. Find any documentation of it that you have and make sure that you're familiar with it. Make sure that it didn't have any sort of end date. I think it can be really helpful, especially for more programmatic types of accommodations, to put review dates in there, and then to sort of stick with your review dates and actually calendar them and review the accommodation on those dates to keep things fresh, so that it doesn't happen that you suddenly have to honor an accommodation that you didn't know about, or you found out that an accommodation has been in place for several years and then it sort of lapsed and you're not sure what to do. But yes, and unless there's some sort of end date in there, the accommodation goes with the employer, not with the ADA coordinator.
Okay, thank you. Next question is, what if an employee states that they're going through some type of treatment and asks if they can come in late on certain times or days, but does not want to submit any paperwork because they say or feel that they're not ready to use their reasonable accommodation until necessary? What should the supervisor do in that situation?
Yeah, so this is one of those that sort of blurs the line between ADA and FMLA. If the employee is asking for a change for a medical reason, they would need to submit either FMLA or ADA paperwork in order to get that request. And I would kind of hold them to it. I would say, listen, you can't use up an accommodation under the ADA. There's no maximum accommodation. It's not like FMLA where you have a certain number of days every year. You're not using anything up by requesting a reasonable accommodation. So you can say that. But in order to protect both the employer and the employee, you need to sort of follow this formal process. And it's really to the employee's benefit if they're not going to be able to come into work on time. In order to protect their job, they need to sort of follow the process to sort of either request FMLA or a reasonable accommodation under the ADA, whichever one applies to that particular need.
Okay. Our next question is, can you tell us about ADA coordinator certification training opportunities, and is certification recommended?
Yeah, there are several ADA coordinator certification programs. We don't administer them at Mass Office on Disability, but some of the ADA centers do. I know Great Plains ADA Center has one. I think the New England ADA Center has one. And those you can Google, or if you want to contact us, we can hook you up with some links to access those certification programs. We don't administer them here at MOD.
We've got one more here. None of the post offices in my town or nearby towns have power doors, and they're also double doors, which I can't access unless someone sees me. These are federal post offices. Is this legal? And also most banks have double doors with no electric door entries. Do they need to make this accessible?
So post offices are federal. I can't say whether a specific post office's setup is legal or not legal. There are certain exceptions under the different architectural access codes if something is, say, in a historic building. But if you have a concern about a facility like that not being accessible, you can take a complaint to the Mass Architectural Access Board for them to look into it.
Thank you. We've got a comment here. Post offices are under the UFAS guidelines through the regional postmaster.
Awesome, thank you.
And I'm going to put a link here to our architectural access page. So
Thanks, Lilia.
that's it for questions.
Wonderful. Well, we are right at 2 o'clock. So thank you all for coming today. And please do reach out to MOD if you have questions. We are here to be a resource to you. So thank you and have a wonderful afternoon.